You may proceed.
Thank you. Good afternoon, Justices of the Supreme Court. Christina Dunn for John Oliver Wooten. And I'm here today to try and convince you that the opinion in Salinas from the United States Supreme Court is not applicable to these facts. And
You say is or is not?
not applicable. And that this case is the type of case that this court should consider that is important to the jurisprudence of our state. To begin with, this case really goes to the heart of the Fifth Amendment. In the Fifth Amendment, the founders stated that a person in a criminal matter should not be compelled to be a witness against himself. And indeed, my client, through the questioning of the prosecutor, was asked to come forward after a crime occurred where he was the only person who was going to be charged, no other people, no other potential defendants, and to give information about that crime to which he would be charged. And I'm asking this court to find that those kind of questions by the prosecutor are strictly prohibited by the Fifth Amendment. I would also, I forgot to say this at the beginning, I'm waiving my question-free period since I have such a brief period of time. Secondly, the prosecutor asked us to, in their pleadings, to consider that there's a Sixth Circuit case, Abbey versus Howe, which speaks to this issue. And a reading of Abbey, first of all, Abbey is an ineffective assistance of counsel case, so the standard is a little different than a straight-up case where a defendant's attorney has objected during trial. And second of all, the concerning conduct by the prosecutor actually occurred during closing argument and rebuttal, not in the prosecutor's case in chief. And in fact, the evidence that was elicited about the defendant's silence was elicited through cross-exam by the defense counsel, not through the prosecutor. A very different factual scenario than the case at hand, where the prosecutor is the one asking the questions, wouldn't you have liked to talk to the defendant? That's what he asked to the police witness who was called to testify. And I asked this court to consider that question, when a jury hears it, they're not thinking this is only applying to pre-arrest conduct. They're thinking this applies to everything. Not just what happened before my client was arrested, but what happened after he was arrested. He wasn't on bond during this trial. He was arrested, brought to court, read his Miranda rights, put in jail. And when a prosecutor asks that question, the jury's thinking they could have come and talked to my client any time prior to trial, and he should have given them some information about this shooting. And I'm asking this court to find that that is what the Fifth Amendment prohibits. It's not a complicated question. And there are very few cases, and this is why this case is important to the jurisprudence of our state, which address this particular issue. When we have a lot of cases where a defendant is being interrogated, they stop the interrogation, they ask for an attorney, or they refuse to answer further questions when confronted with a troubling question. But in my case, my client never speaks with the police. He just doesn't get involved. This is a case he's going to argue self-defense, but the jury doesn't know that. He hasn't put on his case yet. The offending comments come during the prosecutor's case in chief. He should not have to answer those questions, and that's what this court needs to tell the other lower courts of the state, that when prosecutors make these kind of comments in their case in chief, the trial judge not only should sustain an objection, but should probably entertain, should sua sponte order mistrial.
Counsel, is it your position that the prosecutor shouldn't be able to ask these questions as a constitutional matter or just as an evidentiary matter, that on a 401, 403 analysis, the prejudice outweighs the probative value of the questions?
It's a constitutional issue.
And so tell me again, or just explain to me why Salinas doesn't take a big hit at your constitutional
Sure. So in Salinas, what happened was we have a defendant who was voluntarily answering questions.
I agree, this is not exactly that, but the principle, I mean, why isn't this isn't this Salinas +1? Like, why wouldn't we predict that the U.S. Supreme Court would head in the direction that you might lose?
In Salinas, it's presumed that the defendant came forward. I mean, they don't really discuss the specifics of what happened, but he came forward to answer questions on his own, and a particular question caused him to cease answering questions. And that information was used in the prosecutor's case in chief. But going directly to what Justice Alito says in his opinion, he says, the Fifth Amendment guarantees that no one may be compelled to be a witness against himself, but it does not establish an unqualified right to remain silent. A witness's constitutional right to refuse questions, to answer questions, depends on his reasons for doing so. My client didn't refuse to answer questions. In Salinas, this is a direct refusal when questioned by the state, by the government. And most, we can go back to Jenkins, we can look at some of the older Fifth Amendment cases, and it's that tension between the state's questioning and the defendant's refusal to answer questions. And some of that's going to be allowed in to prove guilt. But in this case, there was no questioning. It's very difficult to find any cases that speak to this issue where there was no questioning. And that's why this case is important.
I'd like to ask a question. It seems to me that you have two hurdles in order for your client to prevail. And one is we could agree, let's say that we agree with you on the Salinas issue, therefore the mistrial should have been granted,
Correct.
which you like.
Yes.
But you can't win on your double jeopardy claim unless, because you wanted the mistrial and you got it. So you can't win on your double jeopardy claim unless the prosecutor deliberately goaded
Correct.
or deliberately invited the mistrial. And so we would have to find that the Court of Appeals erred when it said that it couldn't find that there was clear error in the finding of fact.
Well, first I would
Right?
say that the defendant didn't want a mistrial. He really was
Well, you
forced.
moved for a
He
mistrial.
moved for a mistrial, but the judge has stated moments later that he would have granted a directed verdict in this case.
Well,
The-
so maybe you should have moved for a directed verdict.
Yes,
I mean,
in
you
fact,
you
I-
asked for a mistrial,
That
right?
part's too
Yes,
late.
Justice,
Yeah.
it's complicated for a defendant. You have to put yourself in the defendant's position and his attorney at this trial, where the prosecutor has made these outrageous comments, and I would really argue that they're outrageous. You have no choice but to make some kind of objection. You know that something's going
But
wrong.
here's the problem. The trial court was obviously upset about
He
that.
was.
But having heard all this, concluded that this wasn't intentional.
Right. So
That's step one, all right? The trial court is in the best position to make that assessment, typically,
yes,
correct?
I would argue, actually, Chief Justice, that the prosecutor, the trial court judge didn't say that it was unintentional. He said that actually those comments were intentional, but they were made in the heat of argument.
Well, I mean, that meant, I misspoke, because the standard is that the comments were made to goad the defendant into seeking a mistrial. The trial court clearly found that wasn't the case. The Court of Appeals reviewing it said, I don't see clear error. Now, we've got two levels of discretion here that you're asking us to ignore. The first question I've got is, the trial judge was sitting there, he knows, or she knows, I can't remember which,
Judge Callahan.
that this was a motion for a mistrial, and the standard for that, if it isn't with prejudice, is that it wasn't done to go the motion. Did not grant your motion for mistrial with prejudice.
Correct. Well, first, I'm going to argue that Judge Callahan was in error, and that he should have granted it with prejudice. And the reason why, and he misunderstood the law.
Judge Callahan could have decided that.
He could have.
Didn't, so my question is, why do I get to recalibrate that decision?
We have to look at his factual analysis. The standard is it's a de novo standard. Actually, this court gets to review the legal findings based on the factual findings de novo. And we get to go revisit what actually occurred at the trial and decide whether or not Judge Callahan came to the right conclusion. And Judge Callahan was faced with the following things. The prosecutor in their case had put on witnesses. They didn't know what the witness was going to say. They didn't understand that there was a colorable, if not compelling, self-defense claim in this case. This is a shooting at a strip bar. There's a security guard with a criminal record. There's another guy with a gun. They get together, they see something that they think is an inappropriate situation, and they open fire on my client. He obviously, had a gun with him, and shots were fired in response. But the prosecutor didn't know any of this when he started to put witnesses on. I'm sorry.
The standard of review for the determination whether the mistrial was properly declared is determined under a clearly erroneous standard, aren't they?
For factual,
Findings on whether the prosecutor intended to goad the defendant into moving for a mistrial are subject to appellate review under clearly erroneous standard. Isn't that right? That's what we said in Dawson.
We're talking about the facts of the case? Correct.
The findings
The
as to
findings.
whether the
Correct.
intent was to goad, those are clearly erroneous, subject to a clearly erroneous
So-
review.
This court should review on the factual findings, and that's what I'm revisiting, is the factual findings of Judge Callahan. I believe that, he made a relatively hasty decision here. He was, I think he was offended by the prosecutor's conduct. He says. and,
Clearly.
The prosecutor, your case is in the toilet. Obviously you did this because your case was going down the tubes. I was gonna grant a directed verdict. And I don't know, beyond saying that you're gonna lose this case. The prosecutor knew it. This is not a brand new prosecutor. This is an experienced prosecutor, 20 years of experience. He knows when a case is lost, and he knew it. And so he said things that he knew were inappropriate to say. I don't think he
But
expected
that's not
any.
what the trial court found.
That's not what the trial court found, and I'm asking this court to review the findings of the trial court.
Okay.
And that, I have no
Understand.
choice but to do so. That is
Okay.
really what has to happen in this court. That's what this court is for.
Okay.
And in addition, I think that the case law is quite clear, is that if there was a goading, then there is a mistrial with prejudice that should be granted.
You have
Thank you.
3 minutes.
I'm going to reserve just a few for rebuttal. Thank you.
Good afternoon, Tim Bothman, representing Kim Worthy, the Wayne County prosecutor, and the people of the state of Michigan who are the appellee in this matter. Let me say at the outset, this case isn't about whether Judge Callahan was offended. It's clear from other remarks he made he had some antipathy with Mr. Kaplan in this case. But the Court of Appeals didn't find simply that there was no clear error in Judge Callahan's finding that the mistrial was not caused by the prosecutor to gain an advantage. They found that the trial court erred in finding that the question was improper. There was no misconduct in the first place. The trial should have continued, but the defense wanted to end it, and the judge agreed. Now, to return to Salinas, which has been mentioned. In Salinas, the Supreme Court granted cert to determine whether or not an assertion of the Fifth Amendment right in a non-custodial interview can be admitted as substantive evidence showing consciousness of guilt, but Salinas had not specifically said, I'm taking the fifth in the parlance. He had simply remained silent with regard to some questions that he was asked. As one federal court reviewing Salinas has put it, the Supreme Court recognized or took the view that there's a predicate in analyzing the question that they had before it. Was there an assertion of the Fifth Amendment right before you get to whether that assertion in a non-custodial interview is admissible in the case in chief to show consciousness of guilt? And the plurality opinion said there was none. Relying on well-established, long-held law that the Fifth Amendment is not self-executing, the court simply said that the silence during the non-custodial interview was not an invocation of the Fifth Amendment. The two justices would have gone further, Justice Thomas and Justice Scalia, and said we can answer the question that we granted cert on, even assuming the predicate were there, that there were a direct assertion of the Fifth Amendment. There'd still be no constitutional question in the non-custodial setting. As the lead opinion put it, popular misconceptions notwithstanding, the Fifth Amendment guarantees no one may be compelled in a criminal case to be a witness against himself. It does not establish an unqualified right to silence. So what we have here is silence out in the world. The defendant left the scene, was at large for 4 months, ditched the gun, and that was what was the prosecutor attempted to put before the jury in this case. Indeed, this court in McCreevy has went a step further than the Supreme Court had at that time, saying that during a custodial interview, a silence with regard to certain questions may be admitted as substantive evidence in the case in chief. This court has held silence in a custodial interview may be admitted in the case in chief substantively, and then the United States Supreme Court in a case called Bergheis v. Tompkins later on said that once there's been Miranda warnings given and a waiver, there has to be a specific assertion of the right to silence. So this court was ahead of the curve in McCreevy. So,
Counsel, is it your contention that the defendant here had a duty to turn himself in, to come forward? Isn't
my
it
view
your
is it's
duty
not
to
a
go
question
find
of
him?
duty. It's simply that when someone either remains silent or speaks in a situation where there's no government compulsion to do one or the other, There's not a Fifth Amendment issue. There may be an evidentiary issue. In fact, the issue is an evidentiary one. That decision to speak or to remain silent may have evidentiary consequences. There may be inferences that can be drawn from it. In a case such as this, when self-defense is being claimed, and the judge Callahan said in his ruling, we don't have the opening statement from the first trial, the transcript wasn't presented, but Judge Callahan said, I recognize that self-defense is involved, but he can remain silent throughout. So I'm granting the
So it's
mistrial.
not the government's position that it would be proper, relevant, and admissible in every case?
No.
To comment, the defendant didn't turn himself in here, therefore he must be guilty, because
No.
why would he stay away?
I think it's a relevance question in every case, and in some cases it would not be relevant, and I don't think that's, frankly, this is a case where this court should explore that, because the trial that went to conviction doesn't involve the issue, because it only came up during cross-examination of the defendant when he testified in the closing argument. The trial that was aborted got cut off, so that evidentiary issue never was explored. If one were to explore it, and again, I don't think this is the appropriate case to do, I would think that, and I gave it some thought, that probably in many assaultive cases, and almost always probably when a flight instruction is appropriate, in those circumstances, this sort of comment would be appropriate. It seems to me that flight and failure to come forward are almost close cousins, if not siblings. When you put in evidence of flight, you are saying on the other side of that coin, and he didn't talk to the police because he fled. So in those cases, I think it would have evidentiary significance, but in none of the cases does it raise a Fifth Amendment issue. The trial prosecutor did nothing wrong in this case when he asked the question. The trial judge on the defendant's request aborted the trial, and the trial judge, the trial prosecutor having done nothing wrong, and if he had done something wrong, having not done so to goad the defense into a mistrial. If you read the prosecutor's argument as to why he had done nothing wrong, it was very clear and cogent, cited cases. He didn't want a mistrial. He thought he had a good basis for asking the question, and the Court of Appeals agreed with him. Abby Fee Howe was mentioned. Abby disclaims Coyle v. Combs, which was in this court's order directing the MOA, citing Coyle v. Combs. Abby says, well, now, after Salinas, that's not good law because it flatly says the prosecutor can use pre-arrest silence in the case in chief substantively. And I have case after case that is in my brief where the courts are now saying, well, that's what Salinas stands for. That being the case, my request would be the court either say that's what Salinas says, and that's why the prosecutor did nothing wrong here, or simply deny leave after hearing the argument here.
Thank you very much.
Thank you.
I just have a few points of clarification. One is, I think part of the confusion over the standard of review here has its origins in the Court of Appeals opinion. In the Court of Appeals opinion, they indicate the defendant did not properly preserve at trial the double jeopardy violation argument because they did not object to the motion for mistrial being granted without prejudice, which is actually a factual error. And I think it throws some of what we're discussing into confusion. The defendant clearly objected to that.
Yes.
And I would just wanted to clarify that the defendant requested it
It's
without,
preserved. Okay,
without
right.
prejudice. The court does go on to talk about the clearly erroneous standard. This is the Court of Appeals, the lower court. And then they go on to discuss the cases that are standard, Oregon versus Kennedy, and the goading of the defense into moving for mistrial. So I believe the standard's pretty clear. It's really just a matter of whether or not this court finds that what Judge Callahan found was not appropriate based on
What
the
are you
facts.
claiming the standard is? That's very clear.
I believe it is.
I am asking-
I'm sorry, the clearly erroneous standard?
Yeah,
Yes,
okay.
yes. I'm just rereading the Court of Appeals opinion to
Okay.
clarify. And I would take issue with the prosecution's argument. They state that flight and silence go hand in hand. I think that the litany of case law that we have as to post-arrest and pre-arrest silence really puts that argument to rest. There is a big difference between flight and silence, and our courts have continued to find a big difference. Yes, the jury heard about flight. They're going to hear about flight. But there's still a problem when a prosecutor tries to use the fact that the defendant didn't offer information to help solve a crime or to help give the government some indication as to what occurred at a crime scene to the police. The defendant has no obligation to do that. The Constitution prohibits it. You can argue that it's an evidentiary issue, but at first it is a constitutional issue. Thank you.
Thank you. Case is submitted. The case will, the court will adjourn for the afternoon.